Hi, everyone. Carl Steinbeck here. Decided to jump on a Saturday night, talk about the Massachusetts versus Karen Reed case. This is a case that's set for retrial here the 1st of April after a hung jury was declared. A whole lot of legal machinations and mess ups in that past trial. She should have been found not guilty if the jury understood the jury instructions, at least as far as the first and third count. The first count had to do with murder 2. The third count had to do with leaving the scene of an accident. So what I thought I'd do here is there's a lot of central characters that are critical to showing the other side of the story that the prosecution is saying is not reality, not what happened. That Karen Reed striking John O'Keefe, police officer John O'Keefe, is the only means that that can be said to have killed him. But there's a lot of physical forensic type evidence that doesn't align with the government's theory. And what I thought we'd do here tonight is I wanted to cover the cross-examination of now retired police officer, a 30-year veteran of Boston. His name's Brian Albert, and this is the front yard of where Officer John O'Keefe, a Canton police officer, died that night back on a couple of years ago. And we're here now having the trial, and I want to go through his testimony, and I just want to tell you through my eyes how I look at it, and talk about what I see in terms of what I would do maybe differently if I was a defense counsel, and what I think about I'll give you my impressions of what I think about his credibility, how I think a jury will assess it. So I'm basically just going to let you see as it sort of unravels stuff that's popping out in my mind. And if you have questions, I'm going to stop and see those as well. So while I'm doing this, if you guys have questions, I will try to take those as well. So I've never done this before. I'm sort of like multitasking here, and I'm not the best with technical stuff, as you longtime followers are well aware. But in any event, I think I got it. I think I got it in the works now here. So what I'm going to do is I was jumping around looking to find the best sound that that we could use here for tonight. The video is maybe not as good as some of the others like Core TV, but I thought the sound was really very good. So I'm just going to go ahead and jump in that. So what we're going to do is jump right into where the cross-examination starts. So I'm not going to cover the direct examination at this point. I may do it sometime later, but right now I just thought it was most important to get to the cross-examination. The other thing I'm going to talk about is the prosecution and what I think, how they're doing, things that also the judge is doing and should be doing or shouldn't be doing. And so just sort of good, bad, and the ugly. And so let's go ahead and let it roll. So here he is. The first thing I can say is that, and let me switch it over to split screen here. The first thing I want to show here is the testimony when he's on this witness stand here. He's coming back for cross-examination. He's wearing like a sweater. Granted, he's wearing a tie, but he's wearing a sweater. And I just thought that was sort of an odd thing for a retired police officer to be wearing a sweater, sort of like the Mr. Rogers look. I think he's trying to make him look like he's maybe not as tough, because that's one of the things that the cross-examination is going to bring out, that, hey, this guy's sort of like tough and a bully type of sort. So let's go ahead and see what plays out here.
Okay, whenever you're ready, Mr. Jackson.
Thank you, Mr. Albert. This is not this process is not the first time you've testified in the court of law, is it?
No.
In fact, you were a police officer for either just under or just over 30 years. Is that right?
Yes.
During that time, how many times would you say that you testified in a court of law in any capacity?
I would say 100, perhaps.
So you consider yourself to be an experienced witness?
In what aspect?
Okay, so right there, my impressions are that he's acting very nervous. He's a police officer. He's testified many times over 30 years. And so for him to already come across this nervous, I think is sort of telling, and it's giving off some vibes that I think a jury's going to pick up on, that this guy is not comfortable testifying. And think about it. This is somebody that that is so well versed in testifying against a criminal defendant. This should be very comfortable for him, but he's not looking very comfortable at this point.
And as far as being a witness as a police officer,
You've experienced testifying in a courtroom.
yes,
Okay, so
So right there, you can see he's trying to throw back a question. He knew exactly what the defense counsel was asking. He's just trying to trip him up, ask him, playing dumb with it is what my perception is on this. So right there, I think it's a something that me as a defense counsel, if I saw this, I would be thinking this guy is already nervous. He's being rattled and he doesn't want to come clean with me on certain things. So it's probably setting the stage for what's to follow.
understand the oath.
yes,
You understand the gravity of perjury.
yes.
When was the last time you spoke to Mr. Lally before Friday when you began testifying?
So here, a common thing that's asked by defense counsel is, when did you last talk to the prosecution? Because they want to know what kind of preparation they made and how much time was used in that session, what kind of things were told to them. But one of the things I think is very much important to bring out, and if I was defense counsel, I would do this right away on a witness like this. I would right away bring out the fact that he's hired a lawyer and the lawyer's sitting in the courtroom. So imagine this, he's trying to be passed off as like a routine witness in a murder case and has no relation to the murder whatsoever, but he's got a lawyer in the courtroom, a criminal defense lawyer. And so if I was counsel on a case like this, the first thing I would say is something along the lines of, where's your defense lawyer? And make him point him out in the courtroom. And I think that really set the scene for the fact that, wait a minute, this guy's just coming across as a retired sergeant. He was active police officer at the time the murder happened. And yet he's got a defense lawyer in the courtroom, actually. And then the other thing I'd do is I'd follow up and say, when was he retained? How soon did you retain this lawyer? And this is something you cannot ask a criminal defendant if they're on the stand, but a witness for the prosecution, absolutely. This is fair game, cross-examination. And I would also find out how much he's had to pay him, this lawyer. So this is something that you don't find out in discovery matters, because in Massachusetts, they do not allow any kind of deposition in a criminal proceeding unless the witness is going to become unavailable. So that's something that some states do and other states don't allow in their rules of criminal procedure to have a deposition. So I noticed in throughout this cross-examination, a lot of stuff that is being asked here by the defense counsel is stuff that is open-ended question he doesn't know the answer to. And one of the things about cross-examination, you always want to know the answer to what you're asking ahead of time. You try to get the witness fed into a yes, yes, or no, no. You don't want them to narrate. The more they narrate, the more they have control over you as a trial attorney. So you want to make sure you have as much control. And on cross-examination, you can be leading as all get out. On direct examination, you cannot be leading, at least you're not supposed to. On some routine foundational type stuff, you can be leading and get away with it. But on cross-examination, you're supposed to be leading. It's not supposed to be open-ended. But when you have a state like Massachusetts where they don't allow depositions, a lot of those questions will have to be asked and you don't totally know the answer to, and you just have to be more agile on your feet and have quick thinking on how to respond. So with that as a premise, let's go ahead.
Before Friday, the last time I spoke to Mr. Lally was, I believe, on a conference call around the time of my grand jury testimony.
Which would have been 2022?
Yes,
April of 2022.
yes.
You've not spoken with Mr. Lally since that time?
I don't remember speaking with Mr. Lally since that time, no.
What about anybody else from the district attorney's office?
No.
Have you gone over the facts or what you believe to be the facts of your testimony with anybody before you testified on Friday?
The other thing I'm thinking of is he says, I don't remember talking with anybody from the district attorney's office or Mr. Lally, the prosecutor. It's like, that's something as a police officer, you're going to know. You're going to know basically, maybe not the exact day, but you're going to know, maybe not the exact month, but you're going to know exactly how many times you've talked to him, where you're at, what the course of the conversation led to, those kind of details. So right now, I would say, in my mind, he's being evasive already, and I would say the jury can be picking up on that as well.
Including any lawyer that you may have?
No.
Did you discuss any questions that you may be asked on direct examination or questions that you may be posed on cross-examination with any member of the district attorney's office?
No.
Were you told about any exhibits or documents that you might be shown?
Just in the prep.
For him to say no to having any preparation of questions that might be asked, I think is very odd. I think that that's something that's normal course of conduct for him to say that didn't happen seems very odd. And I would be thinking that he doesn't even want to concede the obvious. So something's really bothering this witness.
Prep, I believe I was shown a video of the waterfall bar.
And that was back in April of 2022?
No, that was for the prep for this trial.
With whom did you prep for this trial?
Mr. Lally.
I'm confused. I thought you said you had not spoken with Mr. Lally since April of 2022.
Except for the prep for this trial, I had not.
Okay, that was my question, Mr. Albert.
Okay, I misunderstood your question. I apologize.
Did you prep for this trial with Mr. Lally?
Yes.
When?
Approximately a few weeks ago.
Okay. Mr. Albert, about 45 seconds ago, I asked you, have you spoken with Mr. Lally before your testimony in this process, this proceeding? And your answer was, no, I have not. Did you not understand my question?
I did not.
What was confusing about it?
Okay, this is a routine type of question. For him to say he didn't understand the question, I think is another sign that there's something here that he's really focused on. And maybe he misunderstood the question because he's thinking about something else. But him as almost like a professional witness, this is like really odd behavior.
I was expecting you to ask if I had prepped with Mr. Lally. I didn't hear prep with Mr. Lally, so I didn't know what you were referring to.
So when I said spoke with Mr. Lally, since I didn't say prep with Mr. Lally, your answer was no, I didn't speak with him. I just prepped with him.
Yes.
What's the difference between speaking and prepping?
No, there is no difference. I just misunderstood your question. That's all.
Tell me about that.
And like I said, that's a routine type of question to ask, and different defense attorneys can ask it a different way. So for him to be tripped up on something like that and act like he's confused, or if he is confused, it's just very telling that there's something that this guy's not comfortable about being on the witness stand.
Prep with Mr. Lally.
Sure. I prepped with Mr. Lally about this trial with Mr. Lally, my attorney.
Where did that preparation take place?
The preparation took place, I believe, I'm trying to remember exactly where it was. I actually don't recall where it was.
Could it have been at the DA's office?
Yes, but it wasn't at the DA's office. No, I believe it was somewhere else, but I can't remember if it was here or the DA's office.
Okay.
I'm not sure.
I also asked you a couple minutes ago, did you review any documents or any evidence in preparation for your testimony? And to that question, you also answered no.
Well, I said I reviewed the video.
Well, now you're saying you reviewed a video, but when I
Yes.
asked you, did you see any evidence or documents, anything in preparation for your testimony? You said no, right?
No, I believe I said I saw a video.
Did you misunderstand my question when I asked it the first time as well?
No.
Okay. I'm going to try to be clearer with my questions.
Okay.
Let me try it again.
See, one of the things that prosecutors and also experienced witnesses like this, they can just sort of try to throw off the attorney from their stream of questions, and they can basically play dumb, and it can rattle a lot of attorneys, and they may not go after this witness as hard, and they may sort of just be stumbling over their questions, especially if they have scripted questions, and they'll be harder for them to follow exactly where they're at in the question sequence. So this could be a tactical maneuver by him, but I think that this is not looking good for the government to have a witness acting this way.
What, if anything, have you reviewed in anticipation of your testimony in this trial?
So I reviewed a video of the waterfall.
Anything else?
I reviewed my transcript from the grand jury.
So you have reviewed your prior testimony,
My transcript of the grand jury, yes.
which is prior testimony, correct?
Yes.
When did you do that?
I did that during the prep.
What part of the waterfall video did Mr. Lally show you?
I was a small snippet of the video, and just one of the 20 seconds of video during that night.
Which part? There's a lot of video there. Which part, if you can tell us, which part did you review with Mr. Lally?
It just showed the waterfall. It showed patrons. It showed myself and the other people I was with.
What were you doing in that 20-second snippet of that video?
I believe in one portion of it, I was fooling around with Brian Higgins.
Fooling around?
Yes.
What does that mean?
Means we were just fooling around. That's it.
Now, fooling around, that can mean a lot of different things. So for him to then, on the follow-up question, just say, well, just fooling around. He's seen the video, his memory's refreshed. So fooling around, maybe that's a local thing for someone there in that part of the country. But fooling around can be so many different things that he should have really been more explicit on this. So he's not being more explicit. And so it could be another sign of the person not trying to cooperate and be deceptive.
Fooling around like arm wrestling?
No, I don't think we were arm wrestling. I think we were just pushing each other, fooling around.
Oh, so play fight.
I don't think I would call it play fighting. No, I was just,
Remember seeing part of the video where you took a fighting stance, sort of like this?
I actually don't remember that part. No.
No. Remember a part of the video where Brian Higgins took a fighting stance, sort of like this?
Maybe, yes.
So you
So he doesn't remember him getting in a fighting stance, but he remembers Brian Higgins, the ATF agent, getting in sort of in a fighting stance. So he's also, sometimes you have witnesses that'll also have selective memory intentionally to try to throw off the attorney, to make them think that their memory isn't the best on everything. So if they want to leave out certain details they don't want to talk about, they've already set the scene on minor stuff like this.
approach one another?
I don't think I saw that whole video. No.
Practicing fighting techniques?
I wouldn't call it that.
No,
No.
you can have that. I'm sorry, what was your answer to that, Mr. Albert?
No.
So what you reviewed with Mr. Lally was the portion of the video where you and Mr. Higgins were somehow fooling around. And, well, how would you describe it? If it's not fighting techniques, how would you describe it?
Just joking, being silly, just fooling around.
Okay. Doing what physically?
Doing, if you rephrase,
Physically. I mean, you can joke with words.
right.
Were you just joking with words like a stand-up comedian, or were you doing something physically?
No, I think we were pushing each other, fooling around, joking.
Okay.
Okay, so that's taken this long to try to get that answer out of him. So, like I see Sally Williams is saying, "What's he got to hide?" So that's a kind of impression a lot of jurors are going to have from this kind of testimony, is that this guy's not being a straight shooter, and if he's not being a straight shooter, why?
Did you ever show him how to throw a punch?
Did I what?
Did you show him how you would throw a punch?
I don't remember that. No.
Did you squat down, show him how you want to get low when you're either aggressive or defending an aggression?
I don't remember that exact pose. No.
Did he walk?
This is something that he would remember, even if he wasn't looking at the entire video. He's seen enough. He would have been prepped before his grand jury testimony. So I think this is another thing that just seems really odd for
Over to you and grab you and act like he was going to drive a knee into your stomach?
I'm not sure.
At some point, did you flip him around, grab him in a wrestling hold?
I may have. I just don't remember it exactly.
Do these things sound?
Okay, another thing is, this is a police officer on a murder case. So what I'd be thinking right now is he can't remember details, and he's also not fully prepped to testify in a murder case. And this happened in his front yard. So these are like really red flags for me right now. And I would definitely be thinking it's going good so far for the defense, because he's not being cooperative as a witness.
sound familiar when you reviewed as to your review of the video that you saw with Mr. Lally?
No, I didn't see all those on the video, Mr. Lally.
Did you discuss with Mr. Lally the questions that you might be asked by him on direct examination? Did he go through, here are the topics of conversation that we're going to have?
No, not
Okay, I'll let him answer this.
like that.
That's something that they always do. Okay, they always do that kind of prep, unless the attorney is incompetent especially on a murder case, especially one involving a police officer as a victim. You are going to prep them and give them a rundown of what kind of areas you want to focus on. You may not give a question by question breakout, a scripted type session, but you are going to cover the areas. You're going to make sure that there's no surprises in court. So for him to say no, that's another sign of deception.
Did he go over with you what he believed the topics of conversation might be on cross-examination by either myself or Mr. Unetti?
I believe so, yes.
What did he tell you you might be asked?
So that's something I did admit to, but the normal attorney is going to ask right away on direct, what are they get? This is what I'm going to be asking you. This areas I'm focusing on. And oh, by the way, here's what defense counsel is going to focus on. So this is a normal type of question you'd see in a criminal setting. And so he's just admitting to this part, because otherwise there's no point of even having a session. If you're not going to give him a rundown of here's what I'm looking for and here's what defense can attack you on, why even meet in the office?
I don't remember exactly what he told me. He said,
okay, so right there, he's trying to distance himself. He knows exactly what he was going to be told, what he was going to be asked on cross-examination, and also what a best way to respond to that would be, and go through some kind of scenarios or something like that, or even do a mock scenario and act like your defense counsel and sort of like sound like you're trying to beat him up with some harsh, loud language. So
we could be asked about the night at the waterfall. We could be asked about back at the house, things like that.
Yeah, look at how detailed of a description he's given on the kind of questions he's being asked. I mean, obviously, it's way more detailed than that.
Anything else?
Not that I can remember.
So he won't even admit to the specific kind of questions he was asked by the prosecution and then the defense now. So this is really shocking for a law enforcement officer to not have a better understanding of A, what he's got to be testifying to, and B, his memory of what he was prepared to do and discuss with in terms of questioning for the defense. So right now, I would say this is like very much hurting the prosecution, and it's definitely helping the defense when you got a seasoned police officer like this, 30 years, mind you. He's worked other murder cases, and he's paid, I believe, around, from what I've seen on different research, around $200,000 a year. And that's all the better you can do as a witness? I don't think so.
Is there anything, given your conversation with Mr. Lally, is there anything that you want to change about the testimony that you previously gave under oath in April of 2022?
No.
The fact that you now reviewed that testimony?
No.
You stick by that testimony?
Yes.
Have you watched any of these proceedings on any platform before your testimony?
No.
You've never tuned in to anything that's live streaming, any of the media coverage?
No.
Okay, so right there, for somebody to say he's not looked at anything having to do with this case, no media coverage at all, it's just I think another sign that this guy's got something to hide.
You're aware that your wife testified before you?
Yes.
Did you I don't want to know what the words were. Did you discuss her testimony with her before you testified?
No.
So she came.
So here's a police officer, his wife's testifying in a murder case, and you don't discuss it ahead of time. Look at his body language. His body language also indicates that he's not comfortable answering that question.
Home after testifying in this trial, and you two never brought it up?
No. I just asked her how she was doing, and that was it.
Mr. Albert, are you close friends with Brian Higgins?
That's something that I just think that anybody that's worked in the courtroom setting is not going to find that credible, and I think the jury would also find that credible as well. If you have a lawyer, surely you're going to talk to your lawyer and your spouse. So that's just not credible.
Higgins?
I wouldn't describe it as close friends, no.
He's a fellow law enforcement officer, correct?
Yes,
Works for the ATF,
he does.
the Department of, or the Bureau of Alcohol, Tobacco, and Firearms and Explosives, correct?
Yes.
How long have you known Mr. Higgins?
I think I first met Mr. Higgins about 15 years ago.
How did you meet him?
It was a professional, something at work. We may have worked together. I think at the time he was a Cambridge arson squad member. And I think he came into the city of Boston to do something.
See, all this, I think, that's another sign that he's not comfortable as a witness. He's got something to hide. It just looks very sketchy. Not something you see in a credible witness.
For work.
So you've known him for 15 years and you were with him on January 28th, 2022, correct?
Yes.
And he's the person that you were, quote, joking and fooling around with, right?
Yes.
You had a long road trip with Mr. Higgins on January 28th, 2022, didn't you?
What's the question?
So right there, he asked him something very easily to understand. You had a long road trip with this Higgins, this ATF agent Higgins, and he doesn't even come out and answer it. He's like dumbfounded. What was being asked?
You had a long road trip with Mr. Higgins on January 28th, 2022, correct?
We drove from New York to Boston, yes.
Why didn't he say yes? Why is he trying to delay it out and describe that? He's already testified to that on direct examination that he drove back after flying down to New York City for a fallen officer memorial service, mind you. An officer I assume he doesn't even know.
It's a pretty good drive, you'd say?
Yes.
Consider that a road trip?
Yes.
How long?
I don't know if it was probably somewhere around 4 hours, maybe.
See, again, I don't know, maybe 4 hours. Why didn't you just come out and say, yeah, it's around 4 hours? It just always is, I think, maybe, I don't know. And then he tries this halfway answer the question. So it's just very evasive. And this guy's a 30-year cop. I just don't find this kind of testimony credible.
Once you got back from New York to back up to Boston, the
Yes.
Boston area, the two of you stopped at a location, correct?
Yes.
What was the location?
The hillside.
And what did you two do at the hillside?
We went into the hillside, had a drink, talked, and I think Brian may have ordered food.
So once you got back from that relatively long road trip, that 4 hour long trip,
Notice again says, I think. That's a crutch to be able to bob and weave and try to get out of stuff.
4 hour long road trip, I apologize. You stopped at a bar and started drinking, correct?
Yes.
Did you have anything to eat at the hillside?
I did not.
But Brian did. Brian Higgins did.
I left prior to Brian Higgins eating.
During the course of that road trip, or at the hillside, did the two of you discuss Karen Reed, my client?
No.
Did her name ever come up?
No.
Without telling me anything that he may have actually said, did he mention Karen Reed or the topic of Karen Reed?
No, never.
See, now he suddenly has very clear thinking about whether Karen Reed was ever brought up in the conversation. Everything else sort of before then in this cross-examination line of questioning is a lot of this is he's hedging. He's not very confident and secure. And now he's suddenly secure that no, for sure, Karen Reed is not brought up. So why is that suddenly changing now? Because he knows this is something he's trying to distance himself from, is Karen Reed. That's what my impressions would be.
Did he mention the fact that he had been texting and flirting with Karen Reed 2 weeks prior?
No.
So that subject, according to you, was never addressed or broached by Mr. Higgins or you
No.
during that entire day.
No.
After you arrived at the waterfall, John O'Keefe arrived subsequent thereto, right?
Yes.
How long after?
Approximately 45 minutes, maybe.
And Karen Reed was with him, is that right?
Yes.
Brian Higgins was standing right next to you when she came in along with John O'Keefe, correct?
I'm not sure where people were standing when they arrived.
Well, you remember you saw video, correct?
I don't believe there's any, I saw video of them walking into Waterfall now.
Fair enough, but you saw at least a clip, according to you. You saw a clip of that video of you at the waterfall, correct?
Yes.
You were situated at a high top table, right?
Yes.
Your back is sort of to the camera, is that right?
I'm not sure of the camera angles. The video that I saw, I was at the high top table, but I'm not sure of all the camera angles of the.
You know, this is something that somebody died in your front yard hours later from this. You will know and remember exactly where you're at, who was doing what. And you're also a detective for the Boston Police Department. You're going to know the kind of details of people's maneuvering around that waterfall bar. That's the kind of thing that you automatically have these senses as a law enforcement officer, is what people are doing. And you're always watching your back, or as we say, watch your six. And so for him to act like he doesn't really know where people are at, even after he's seen video, it's just not sounding like he wants to really talk about any of this.
Of the waterfall.
Brian Higgins is the guy with the sweatshirt with maybe a Harley Davidson emblem on the back or something.
I'm not sure what he wore that night. I'm sure he had a sweatshirt on, but I don't know what the emblem was.
Okay. He was standing right next to you in the video clip that you saw.
Yes.
Okay. In other words, that was the video where he was standing right next to you, and you two turn to each other and start this play fighting thing.
Yes.
Think about it. They spent the whole day together. They spent 4 hours driving a car back from New York City. A Harley Davidson jacket is something that's really going to stand out. So why wouldn't he just admit to that? And you can also see it on the video. So again, it looks like he's not wanting to talk about specific details. So ask yourself why.
So if it's that time or sometime around there at the high top, you were in proximity of Brian Higgins when Karen Reed and John O'Keefe came into the bar, correct?
I just don't recall the timing of when they came into the bar.
All right, Mr. Albert, did Mr. Higgins say anything to you?
Wait a minute. He just did. Earlier, he said they arrived approximately 45 minutes after he got there, right? So now he's saying he doesn't know. So that's something Jackson was focused on his next question, so I don't think he picks it up.
That time, about John O'Keefe arriving with Karen Reed at his side.
No.
Did Mr. Higgins say anything to you about being upset that Karen Reed had shown up with John O'Keefe?
No.
Describe your relationship with John O'Keefe, if you would.
So I didn't know John that well. I had only met him a few times. But every time I met him, it was cordial, pleasant. And I would consider him to be a co-worker, even though I never really worked with him directly. He seemed like a nice guy. I knew his whole story about the fact that he had taken his niece and nephew after a tragedy in the family. And I had an unbelievable amount of respect for him doing that. But I can't say that we were good friends because I didn't really know him all that well.
You were far better friends with Brian Higgins than you were with John O'Keefe. That's fair to say.
Yes.
So think about that as we go on here down the line. He's talking about all this great respect he has for John O'Keefe, taking in some nieces and nephews. I believe it was a niece and a nephew. So why would he have that kind of respect for him? And yet the rest of the events that played out that night, you're going to see that he didn't have any interest in going out to see what was going on in the front yard after knowing that he might be dead. So
on Friday, you were asked whether or not you knew my client, Karen Reed, correct? This meeting a couple days ago during your direct examination.
I believe so, yes.
You were also asked the same series of questions at another grand jury not involving the Commonwealth.
So this one, he's talking about the federal grand jury that had happened.
Remember that in June of 2023?
Yes.
I want to be clear about this other hearing. That was a non-Commonwealth hearing in front of a grand jury, correct?
Yes.
All right. Mr. Lally and his colleagues were not there. Is that right?
Yes.
I was not there. Mr. Yannetti was not there.
Yes.
Or Miss Little.
Right.
Okay. At that June 2023, and I'm going to talk about a couple of dates, so I don't want to be confusing. At that June 2023 non-Commonwealth hearing, you were asked some questions about whether or not you knew Karen Reed before January 28th, 2022.
I believe,
That's not your question.
I believe so, yes.
And you testified, before you testified, you were sworn an oath.
Yes,
Same oath that you swore in this trial, correct?
yes,
Swore to tell the truth, the whole truth, and nothing but the truth?
yes,
And you knew that you were testifying under penalty of perjury in that hearing as well, correct?
yes,
And you testified at that non-Commonwealth grand jury that you, quote, believe Karen was with John the night he came into Hillside, a female that looked similar to Karen from the waterfall came in with him on that night. And I assume that was her, but I can't say for sure.
See, again, being evasive, right? So all the publicity that happened after John O'Keefe was found dead in his front yard, he's not going to know what she looks like and remember, oh yeah, that definitely was the girl. Oh, it might look like somebody like her. So this kind of evasiveness is very telling, and it will continue most likely. Let's see what happens.
End quote. That was your testimony before that grand jury.
yes,
But you were also asked a similar question in April of 2022 by Mr. Lally at his grand jury. You remember that?
no,
Let's start at the beginning. Before you testified in the April 2022 grand jury, more than a year earlier, and just 3 months after this incident, you were sworn an oath, correct?
yes,
Same oath that you took in June of 2023, right?
yes,
And the same oath you took on Friday.
yes,
Isn't it true that you were asked the question whether or not you knew Karen Reed on January 28th, 2022, and you testified, quote, I've never met or seen her before, end quote.
Wow. So for him to say that, and then to know that she's got her picture plastered all over the news media and whatnot, he had still an active duty officer. So he would know exactly what she looks like after she got apprehended, arrested. And so for him to say he doesn't know what she looks like back then, again, it's a sign that he was being evasive and trying to hide the obvious. So these are good points the defense is bringing out.
no, I don't recall that.
Didn't you indicate that you just testified, I'm sorry, that you reviewed your grand jury testimony in anticipation of this trial?
Yes,
You'd read the whole thing,
yes,
and you don't recall making that statement?
no,
I mean, this is a big deal. Him saying he doesn't know Karen Reed, he's never seen her before, and yet they spent time there at the bar that night. This is very much something he's trying to run from. So the question that is going to be on the jury's mind is, why is he trying to run from this?
Yeah, Coach Young?
Yes, and I'll see Counsel at sidebar when you leave that with the witness.
Just please take a look at that.
sure,
Okay, so right now he's looking over a statement, some excerpt from the grand jury testimony. So defense wanted to have a sidebar to get some feeling from the judge on something. So
Yeah, Coach Young?
back
Yes.
here, ready to go forward.
Mr. Albert, have you had an opportunity to review that?
I have, thank you.
Does that refresh your recollections to what you said before the grand jury in April of 2022?
Yes, but you didn't read the whole quote though.
Right. The whole quote is the following. Question. So the female you had never met before, is that fair to say? Answer. No, I've never met her or seen her before, period. Maybe once, but I don't think I've ever had a conversation with her.
So right there, look how he waffles from saying he's never, ever seen her before to maybe once. So that's a huge discrepancy.
That was the entire quote, correct?
That's the entire quote. Yes, that's not what you read earlier, but yes,
Well, what I read earlier was, I've never met or seen her before. Those words came out of your mouth, correct?
that's not my whole sentence. No,
You said, I've never met or seen her before, and then you said, maybe once, but I've never had a conversation with her, I don't think.
Right. Yes, that's my sentence.
Okay, so which is it, Mr. Albert? What were you saying? Were you saying you met her and had a conversation with her? Or were you saying, I've never met or seen her before? Which one of those two things was true?
I was saying that I met her maybe once.
Actually, what you said was, I've never met her or seen her before. Your words, not my words, sir. Isn't that right?
No, because in the next sentence, I say I met her maybe once.
So you literally changed your testimony within your own testimony.
Objection.
No, can you answer that, Mr. Albert?
I believe I qualified my first.
Okay, this is something that, why would Lally object to this? This is a perfect line of questioning. And why wouldn't the judges just make a ruling on that and say, instead of asking the witness directly, can they answer the question? It's sort of like cutting off the defense momentum. And it's something that I think is very troubling because this goes on a lot, as you'll see. And so why didn't she just rule on it? If there's an objection, just say overruled or sustained. Why is she trying to help out this witness and cut off the defense counsel from asking it again?
First sentence with his second sentence.
So what changed between the first sentence where you indicated unequivocally, I've never met or seen her before, and the second sentence when you said maybe once?
I'm not sure what I was thinking at the time that I said that.
Isn't it true, Mr. Albert, not only had you met Miss Reed, but you had spent several hours with Karen Reed and John O'Keefe 6 days before this incident. Isn't that true?
No.
In fact, on January 22nd, 2022, 6 days before January 28th.
Notice he's very definitive and he says no. He doesn't say I don't think so or I don't recall. He's definitely trying to convey that he's not met her before that night.
You socialized with Karen Reed at the Hillside Bar for several hours, didn't you?
I was at the Hillside Bar the week prior, yes.
It was a Saturday night, correct?
Yes.
You were at the bar.
Yes.
There were several other folks at the bar, correct?
Several people, yes.
That included Chris Albert, your brother.
Yes.
A guy named Tim Daly.
Yes.
Daily, is that right?
I'm not sure how to spell his last name.
Julie Albert was there.
Yes.
Jen McCabe was there.
Yes.
Matt McCabe was there.
Yes.
John O'Keefe was there.
Yes, he was.
And Karen Reed was there. Correct?
Yes, she was.
Wow. So think about that discrepancy.
In fact, Your Honor, may I approach?
Yes.
I'd like you to take a look.
Notice he's not very comfortable here right now. He knows he's waffling. He knows he's all over the place. He can't keep his story straight. And there's something bigger here he's trying to hide from, it looks like.
Got a photograph. Just look at that to yourself for a second. Tell me if you familiarize yourself with it and then look up when you're ready.
Yes.
May I approach?
Yes.
Actually, I don't need to. Mr. Albert, you can stay there. Do you recognize the photograph that's before you?
Yes.
How do you recognize it?
Well, I recognize the people within the photograph, and the background of the photograph looks like the hillside.
Does that appear to be a photograph that was taken on January 22nd, 2022?
Yes.
You were at the Hillside Bar?
Yes.
I published this one.
Okay, is it already in evidence or you?
I'm sorry,
So you put it in evidence first and then you publish?
Keep in mind, every single one of those names that was mentioned, he had no hesitancy in confirming the fact that they were there on the 22nd. And so why is he able to have such good recall on that? But the one person he can't recall is Karen Reed.
May I have that marked as next in order?
Yes.
And then
The exhibit 67.
Thank you.
permission to publish, Your Honor?
Yes.
Thank you. You see that photograph? It's the same photograph that you're looking at in front of you.
Yes.
Does Describe who the people are going from left to right, sir.
Chris Albert, myself, John O'Keefe, and Tim Daly.
Right there you have it.
And this was on January 22nd, 2022, at about 11 p.m., correct?
Yes.
No
Yeah,
problem to that memory
Yes.
there.
Mr. Albert, who took the photo?
I don't know.
Karen Reed took the photo, didn't she?
I have no idea who took that photo.
Right there.
Karen Reed
after
took the
giving all-
photo, you're literally staring right at her, correct?
I don't know who took the photo.
Well, who else do you think?
Sorry, after knowing all the details of who was there, and then all of a sudden he has no recollection of her being there and doesn't know who took the photo, has no idea. The jury's just not going to find that credible.
Well, there were a lot of people there. You mentioned my sister, two sister-in-laws, a brother-in-law. I'm not sure.
We can turn the lights back on, please, and take the photo down.
Did you ever see this photo from Jim McCabe?
Yeah, look how evasive it is.
No,
As a
Did you ever see it from
witness.
Julie Albert?
no.
Chris Albert didn't take it. He's in it.
Right,
Tim didn't take it. He's in it.
right,
You obviously didn't take it.
right.
And who's the guy on the far right?
Tim,
That was Tim. Who's the guy next to Tim?
John. Right?
So who do you think?
Do you still need the photo up? I'm sorry, I thought you were done with it.
Do you remember?
Yeah, it was John, yeah.
Okay. With the
Yes.
baseball cap on, correct?
Yes.
I don't need it. No.
Okay.
So given the fact that you were never shown that, you've never seen that photo before today, right?
I saw a photo that was sent to me in Discovery or to my attorney that showed only, I believe, me and John in the picture.
Okay.
I think it's the same photo, only that's blown up to show everybody.
Got it. So given what you now know about that night, who was there, the fact that John was posing for a photo right next to you, who do you think took the photo, sir?
I have no idea who took the photo.
Could it have been Karen Reed?
Objection.
Sustained. Let's move along from
In
that,
fact,
please.
Okay, right there. He's been denying that Karen Reed did it. He didn't know who had taken the photo. He was trying to impeach him in a number of different ways. He asked him one more time. So why would Lally care about the one last time he's being asked of this witness about who took the photo or not? So, and the judge sustained that objection. So I can see that happening, but it's like, why would you object to that, prosecutor? This witness is not coming across as credible. So if you're a prosecutor, let it go. What does it hurt to ask one final time? And so anyway, I think the point's been made though. This guy is evasive as all get out, and he's just not credible.
you were interacting with Karen Reed and John O'Keefe throughout that evening, correct?
I remember having conversations with John that evening. I don't necessarily remember speaking to Karen that evening.
Irrespective of whether or not you spoke to her, you obviously saw her there.
Yes.
You were there with her for a couple of hours.
Well, I wasn't there with her for a few hours. I was there with other people.
Okay. So without splitting hairs, she was there, correct?
Yes.
John was there.
Yes.
You were socializing with John.
Yes.
She was right next to him.
Sometimes, perhaps not, maybe all the times I was talking to him, no.
So you were socializing not exclusively with her,
Right.
but certainly socializing with her 6 days before John O'Keefe ended up dead on your lawn, correct?
We were there at the same time, yes.
And yet, when you were asked 3 months later, do you know Karen Reed, or how do you know Karen Reed? The actual question was, so the female you've never met before. Is that fair to say? That was Mr. Lally's question. And your immediate response was, no, I've never met her or seen her before. Correct? That's what you said.
That's not my whole response, no.
That's what you said immediately upon that question, sir.
That's the beginning of my response, yes.
That was
Yeah. So keep in mind, this is a hot topic. He doesn't want to come clean and just come right out and say, yeah, I saw her the 22nd. She was there multiple hours. We all hung out. She took our photograph. He's just trying to do the maximum amount of distancing he can from anything having to do with Karen Reed. So the question the jury's going to ask is why? Why can't he admit the blatant obvious? Why is he flip-flopping like this? And this is a professional trained cop that has done this so many times in 30 years that this should be very comfortable for him just to say it like it is. But you can't say it like it is.
Was the first sentence out of your mouth?
Yes.
You also testified at the subsequent grand jury in June of 2023. When asked, what was your impression of?
Keep in mind, they can't describe it being a federal grand jury. The judge kept this out, didn't want jurors knowing there's a federal grand jury. And I think that would have lent some credibility to the fact of what defense is trying to say, which is that there's something other than what the prosecution's making out happened that night. And the feds are even looking at it. So that kind of inference and deductions they could have from that fact are kept from this jury. So that's why you can also see prosecutors do stuff to keep out the truth when it's actually favorable to the accused. And so this is sort of like what I see many times where prosecutors do the maximum extent possible they can to keep out favorable information from the defense from going before the jury. So this is not, maybe it's not exculpatory per se, but it's definitely helpful to set the scene of the fact that there's something shady going on with law enforcement involving this case.
Ms. Reed, you said, quote, I honestly didn't really have one. I didn't have any conversation with her. I just kind of saw her from across the table. I didn't really think of it either way. Correct?
I don't know what that question is referring to. Is that for the waterfall or is that for Hillside?
Hillside.
Okay. Yes.
All right. So in June of 23, a little over a year later, your testimony significantly changed from no, I've never met or seen her before, to I really didn't have a conversation with her. I saw her across the table. I didn't really think of it either way. Correct?
No, I think those are very similar testimonies.
When you were asked in the other proceeding, and this is about the waterfall, question, did you talk to Karen Reed at the waterfall that night? You answered unequivocally, I did not. Is that right?
Yes.
And that's what you told the June grand jury, June of 23, correct?
It's referring to.
See, the point I'd be making is that he prepped before the grand jury with his lawyer, no doubt. And that's something that Jackson should be asking about. What kind of money and time did he spend hiring a defense lawyer to prep him for this grand jury testimony?
To the state grand jury?
No, I'm sorry.
Okay.
That's why I'm using dates. I'm trying to be careful.
Right.
April.
I'm just not clear on what all the dates were.
I'll see if I can clarify.
Okay.
April 2022, state grand jury. June of 2023, a different grand jury.
Okay.
When you were asked at the June of 2023 grand jury, did you ever talk with Karen Reed at the waterfall that night? Your answer was, I did not. Correct?
Yeah. Yes.
With the court's permission, could I play a small clip from Exhibit 53?
All right, this question here about when I was a prosecutor, did I find any kind of pressure to hide anything favorable to defense? No, you're basically breaking the Constitution requirements for a fair trial and due process by denying evidence to the defense. And if you're trying to hide anything that could be helpful, it's actually something you can wind up having the case busted on appeal. So why would you want to try a case, only have it reversed on appeal? So no, I would say there's no pressure to hide stuff. In fact, I have the complete opposite position, and you'll find that for prosecutors that know what they're doing and know when they got a guilty party to prosecute, let them have their day in court. You don't have to object all the time. You don't have to do this railroad job attempt to prevent the defense from saying their presentation and their evidence that they want to admit. It's it's something that I invite because you know what? Because I can completely turn around, flip the script on them, turn their witnesses against them, expose the fact they don't know what they're talking about, and it makes it more of a true duel of sorts for the truth to come out. And so all this objection and trying to keep out expert witnesses and all that, it really is showing y'all how bad it really gets in the criminal law arena, how political it gets, where they don't even look like they're trying to get a defendant a fair trial. So regardless of whether somebody like Karen Reed is guilty or not, if this kind of stuff goes on routinely in America in many courts, you see how easy it is for an innocent person to get railroaded and convicted. So you better have a good defense lawyer, because if you get a bad judge, you got bad police officers, you got bad prosecutors, you can very easily wind up in this kind of a star chamber and be railroaded and convicted. All right, going back then.
Okay.
Starting at timestamp 11:53 and 15 seconds. If we could just play this, and I would direct your attention, sir, to the upper right-hand corner. Pause it. Do you recognize the individuals in this clip?
Yes.
Check out that
You recognize
Harley Davidson jacket. It's so noticeable. That's something you're going to remember.
that person.
Yes, I believe that's me.
You recognize that person.
I do. I believe that's the defendant.
Ms. Reed,
Yes.
what does it appear you are doing as it relates to Ms. Reed in this clip?
It appears that I'm talking at the table. I don't know if it's specifically to her, but
And it compares to what he said earlier, that he'd never seen her before, never met her before.
Did you see the part of the clip starting at 11:53 and 15 seconds, going back about 30 seconds?
yes.
Who did it appear you were talking directly to, and who did it appear was answering directly to you?
I looked like I was speaking, but I can't say for sure that I was directly talking to the defendant.
Even though it looked like you were looking right.
Yeah, that's something that the law enforcement typically do, prosecution and defense. They don't want to humanize the defendant, so they always refer to whoever's in defense counsel table, the defendant. They always refer to as the defendant, usually because they don't, like I say, it's just a matter of trying to be cold and impersonal to prosecuting somebody, because they figure if they're impersonal and cold about what they're doing to the person in the defendant's chair, then it's easier to get a conviction. So that's the reason for that. So that's something he's done over and over again. Always refer to the person that at defense counsel table that's being accused as the defendant, and not by their name.
At her and leaning toward her as she's answering.
I was definitely looking that way. I don't remember the conversation.
The reality is, we can take that down. The reality is, Mr. Albert, you had many conversations with her throughout the night, like you would with anybody else you were socializing with, correct?
No.
It's not like you ignored her through that evening.
No, I think that just the positioning of me on the other side of the table, I didn't have really much contact.
There was only one person between you, and that was Mr. Higgins.
No, I don't think that was the setup for the whole night.
I didn't say the whole night.
Right.
I was talking about right then.
Right. So,
That's an example.
right. What's your question? Rephrase your question, please.
Did you or did you not have conversations with Karen Reed that night?
I do not recall having conversations with Karen Reed that night at all. No.
And that's what you told the grand jury under oath, notwithstanding this video evidence to the contrary.
See, by saying I do not recall, that's a weasel way out to be able to have the consciousness to say, well, I don't really remember. It's something that people that are conscious that they're lying, to try to diffuse it from their body language showing that, they'll say stuff like that. So this is just another indicator that he's trying to distance himself from Karen Reed. And it's just so obvious again that he's willing to lie about it. So what's he got to hide?
Yes, I don't think that video shows that.
I'm going to let that stand. Next question, please.
You were interviewed by Michael Proctor on January 29th, the day after this incident, correct?
Yes,
And that was 6 days after you spent several hours, Karen Reed, at this event, correct? 6 days later.
yes,
You were asked by Michael Proctor whether or not you knew or what your relationship was with Karen Reed, correct?
I don't recall if he asked me that.
Did you say to Michael Proctor, quote, that you quote,
Again, he doesn't believe or remember what was going on with his conversation with Proctor. Of course he remembers that.
did not know Karen Reed, end quote?
I may have, yes.
But when you made that statement, you did not know that Ms. Reed had a photograph of you at the Hillside Bar, correct? You didn't know that photo existed, did you?
Objection, Your Honor.
Sustained.
Sir,
Okay,
you were
right
trying
there.
to distance yourself.
Right there, that is a perfect impeachment question. And for Lally to object to this line of questioning, this one question about, it shows that he thought he could get away with the lie because he didn't remember that there was a photo, right? So this is like very much exactly what the Sixth Amendment's talking about when you have the right to confront your witnesses, those that are accusing you, any of the witnesses of the state, such as this Brian Albert. The bottom line is this kind of stuff is how you show somebody is lying. And so for the prosecution, you're going to see it more and more coming up here where they're objecting and objecting, objecting. And it's really good things that the defense is bringing out. And the prosecution knows it, and that's exactly why they're objecting. And the prosecution is supposed to be all about fair and just prosecution of the guilty. And so the thing is, there's nothing fair about so many of these objections. So we'll get into more of that later here, but it's just really going to get bad here. And
From Ms. Reed in your interview with Michael Proctor, weren't you?
Objection.
Were you?
No, I was not.
okay, again, why doesn't she just let the defense counsel handle the witness? Okay, why doesn't you just say overruled and allow Jackson to continue on? It's like she's trying to protect the prosecution and the defense. It's very, very disturbing to see.
Mr. Albert, you were trying to distance yourself from knowing Ms. Reed in your grand jury testimony with, well, I'll use the date, in your April 2022 grand jury testimony, weren't you?
No,
You were further trying to distance yourself from Ms. Reed in your June 2023 grand jury testimony as well, correct?
no,
You thought that it was important to try to deny knowing John O'Keefe and Karen Reed during those interviews and or that testimony.
Objection.
Sustained.
Okay, this right here, this is ridiculous. My gosh, this is like so much exactly what the Sixth Amendment's about. There's case law supporting this kind of questioning. And it's really, as a judge, as a gatekeeper, to keep it from being overly repetitive, asked and answered, or maybe hostilely abusing the witness or something like that. He's doing none of that. Jackson's acting totally professional. And he's basically rolling up exactly what his motives could be and why he's trying to distance himself from Karen. And the prosecution knows this is really making him look bad. And so what does he do? He throws out an objection there. And what does a judge do? Just completely outside her lane, denies this from being answered. It's just really, really disturbing to see. You're not going to get a fair day of justice here in this courtroom. I tell you that.
Mr. Albert, you knew that if you admitted having a relationship with John O'Keefe and Karen Reed, you'd have a lot to answer for when Karen Reed's boyfriend ended up dead on your lawn 6 days later, correct?
Objection.
Sustained. You can ask the question differently.
Okay,
You knew
right there
that there would be question.
Let's see. How do I?
Quote, did not know Karen Reed, end quote.
I may have, yes.
But when you made that statement, you did not know that Ms. Reed had a photograph of you at the Hillside Bar, correct? You didn't know that photo existed, did you?
Objection, Your Honor.
Sustained.
Sir, you
I already covered this, but again, it just highlights how much you don't get a fair day in the courtroom there with this judge and this prosecutor. This prosecutor's been doing it for 20 years. 20 years he's been treating defendants this way. I don't think he's just exclusively singling out Karen Reed, but this is kind of way you get justice. And it's not just there in Massachusetts. I've seen this in a lot of courts that I've been in. It's like a, they're trying to hide the ball from the jury, and they want nothing to do with letting the truth come out. And if you're confident the defendant is guilty, let this kind of stuff come out there. But no, you got to block it because you got a house of cards that he's going to be blown over.
were trying to distance yourself from Ms. Reed in your interview with Michael Proctor, weren't you?
Objection.
Were you?
No, I was not.
Yeah, why did she stick her nose out like that and say something like that? That's just really bizarre. I've never seen it this much from a judge before. So it's like she's trying to protect it and allow him to feel comfortable in her asking it. He's safe with her asking it, not a defense attorney. And it builds confidence that this witness is thinking, hey, if there's an objection, maybe the judge is going to bail me out. And the prosecutor's thinking, hey, I need to keep objecting because if this witness is looking bad, maybe I just need to keep objecting because this judge is going to sustain everything.
Mr. Albert, you were trying to distance yourself from knowing Ms. Reed in your grand jury testimony with, well, I'll use the date, in your April 2022 grand jury testimony, weren't you?
No.
You were further trying to distance yourself from Ms. Reed in your June 2023 grand jury testimony.
Perfect cross-examination type of questions. These are the kinds of things that Constitution and case law totally support.
As well, correct?
No.
You thought that it was important to try to deny knowing John O'Keefe and Karen Reed during those interviews and or that testimony.
Objection.
Totally legitimate. It's all in the same line of questioning, right? He's building up to the fact that not only Karen Reed trying to distance yourself from, but also John O'Keefe. And there's an objection to that. What's the basis? So in in Massachusetts, you do not have to state the basis if you're objecting. But what I found out under the rules is if you're the person that has someone objecting to, you have the ability to try to explain yourself. Okay, so what I'd recommend doing if I was in a situation like this, and what I do when I face prosecutors like this, I'm just going to let them know I'm going to have a sidebar every single time. We will not get through one witness in a day or two based on you continually objecting. And I'm going to take so much time. And even though the jury's going to get ticked off, I will win those objections because these are wrong. And you need to call it out and you need to fight for it. You need to call out the judge in a sidebar and say why exactly this is legitimate. And I'd also have the case law printed out. I have cases like Davis v. Alaska, a 1970s case. That's one of the paramount cases that talks about the rights of cross-examination. There's a litany of different cases that they can use to show cross-examination is a fundamental constitutional right. So for a prosecutor to not have that insight of what the Sixth Amendment is about, if I was a judge and I saw a prosecutor objecting to stuff like this, and he was habitually doing, number one, I wouldn't be sustaining his objections or interjecting myself into the line of questioning of a witness. But I would actually tell the prosecutor, you better go home and read the Sixth Amendment and case law that discuss it because you have no clue what you're doing in your job. So anyway, that's how disturbing and disgusting it is to see this.
Sustained.
Just terrible.
Mr. Albert.
This is absolute garbage. I'll tell you right now. This is absolute garbage, sham courtroom theatrics right now. Okay, this is not the way American jurisprudence is supposed to be handled.
You knew that if you admitted having a relationship with John O'Keefe and Karen Reed, you'd have a lot to answer for when Karen Reed's boyfriend ended up dead on your lawn 6 days later, correct?
Objection.
Sustained. You can ask.
Wow. Sustained. Wow. That is completely what the Sixth Amendment's embodied in the case law. But they don't care. They've been getting away with it in Massachusetts, obviously, because why would this be allowed by the higher courts?
Ask the question differently.
Sustain and ask a question differently? How? That is how you're supposed to ask it. You give leading questions, showing the premise of what really was going on behind the scenes and what his motives are. Motives is one of the main areas of cross-examination. You have motives, prior inconsistent statements, bias, and you also have prior convictions. Those are the main fertile areas of cross-examination as a trial attorney, you know. And so for Jackson to be cut off like this, I can only imagine how mad he must be going through this, because the prosecution is trying to nip him off from his momentum, cut him off his knees. And then you got the judge also siding with the prosecution on some of this unconstitutional, bizarre behavior. So why isn't he calling a sidebar? I don't get it. You need to fight. You need to fight and do not give up and quit and go on to the next question. So, and how do you rephrase it? You know, I'd ask for a sidebar. I said, Your Honor, tell me how my question is not legitimate and how the rephrasing it is going to make it sound any different. Is it supposed to be rephrased so this witness is not as directly confronted with what his motives are? I mean, what's the judge really driving at here? I have no idea, other than the fact that it looks like she's biased and trying to help the prosecution.
You knew that there would be questions about your relationship with Karen Reed if it were not known that you knew her before her boyfriend ended up dead on your lawn 6 days later, correct? There would be questions.
Objection.
Can ask it a different way. That's sustained.
Garbage, absolute garbage ruling. Prosecution, shame on you. Disgusting. You have no business.
So you lied under oath when you said, I've never met or seen her before, correct?
No, because that wasn't my whole statement.
The sentence, I've never met or seen her before, pretty unequivocal, isn't it?
That was not the context of my whole sentence.
But those are the words that came out of your mouth, right?
Initially, and then I remembered that I had met her once.
Let me just ask it this way.
Sure.
Is that sentence?
Think about it also. Before he's being brought before the grand jury, he's had a chance to talk to his lawyer about it. He knows who the defendant is. This is a question that he's not going to like suddenly like, oh, wait a minute. Yeah, now I recall. Yeah, I did see her. Oh, yeah. Oh, no, it's not somebody asked out of the blue. This is the main person the government is saying is responsible for the death of a police officer. And you're going to be waffling your answers like this? Of course, it looks like he's distancing himself from Karen Reed.
It's true or false? That you had never met or seen her before. True or false?
That portion of that sentence is false.
Let's get this on the record. Did John O'Keefe
That's actually something I give him credit for. He admitted it was false. He's basically got an admission that he gave some false testimony, because that is a big waffling thing. And like I say, if I was cross-examining guy like this, I'd bring out the fact that his mind was totally focused on Karen Reed before he went in there to testify. So him not having some kind of waffling like that, him talking to his attorney, him knowing how critical his role is as a witness in a grand jury proceeding, him as a law enforcement officer knows exactly what this is about. So for him to be waffling, it's very telling. And just again, look how many minutes we've been covering now, how many waffling type of statements he's given, how many deception type statements he's given, and his body language shows that he is not comfortable to be there at all. And it's like he's got something to hide.
come into your house at 34 Fairview at any time on January 29th, 2022?
Absolutely not. I wished he had.
And you're as sure about that as you are about the statement that you had never met or seen Karen Reed in your life,
Objection.
correct?
Sustained. Can ask it differently, Mr. Jackson.
Okay, sustain. Why would you object, prosecutor? Lally, you have no business being a prosecutor. If that you're not concerned about a fair trial for defendant. I don't care whether it's Karen Reed or anybody else. Prosecutors that act this way is absolutely disgusting. It turns my gut. And if attorneys don't know how to fight back and push against this, then you can see innocent people being convicted. And that's what really gets my hide. That's what really burns me up when I see this. Okay. So it's the overall approach, because I know this is the kind of stuff that goes on in so many courtrooms, and it's just absolutely sickening. Yeah, it is scary too, right? Interesting comment there. I don't know exactly when he left. I know he charged shortly after. Yeah, and he gets like what is it? He gets $8,000 a month as a retired police officer. I mean, that's a lot of money. I mean, you have to to make that kind of money, you have to be almost like a full bird colonel in the military. So for a sergeant from Boston to make that kind of money, my gosh, that is like, it is very lucrative. These officers, if the research is accurate, they make over 200,000, the leading cops at Canton. So a little small town, they're among the most wealthy people in the community as law enforcement officers. Why is that the case? How can that be allowed? I thought public servanthood was not about being able to make yourself that wealthy. Look at the kind of house he had. He basically had $1 million house, raised a family of 7 in there, and also had a pool, huge yard, 0.77 acres, all that kind of stuff on a sergeant's salary.
I want to get back to the waterfall. I know I asked you this about the hillside. I may not have asked you about this specific question about the waterfall. Did Brian Higgins say anything to you about John O'Keefe and Karen Reed walking in together at the waterfall?
No.
Did he say anything or give you any indication that he was upset about Karen Reed showing up with John O'Keefe?
No, he did not.
It appeared from your observations that John and Karen were getting along at the waterfall.
I didn't really notice, but I didn't notice anything was wrong.
They appeared.
I'm just thinking back to that whole car ride up. He never saying about Karen Reed. He was having some flirtation text with Karen Reed previously. So she never came up. I just wonder, maybe they're talking about who's going to be there that night, stuff like that. So it could very well could have been something that was discussed.
Pleasant,
Yes.
happy.
I don't know if they appeared happy. I didn't really notice.
They were interacting with others.
Yes.
You didn't notice any tension,
No.
no argument,
No.
no yelling or fighting.
Nope.
They looked like a normal, happy couple.
Yes.
Did either of them appear to you to be completely drunk?
I didn't have a ton of interaction with John or Karen that night, so I can't really say, but it didn't appear that they were drunk. No.
You had an opportunity to review them.
So think about it, where he went from saying he never met her before to maybe I saw her one time, and now he's talking about her levels of sobriety and stuff like that. So he's really been forced and been confronted to admit, yeah, he knows who she is. He's seen her that night in a roundabout way. So it is really, really bizarre how much he's trying to bob and weave and deceive. Yeah, that's another thing, Aunt Nancy, is that he can be looking at the prosecutor. That's something that also experienced police officers like that can do. They can look at the prosecutor and say, hey, aren't you going to help me out here, bail me out? I'm not looking good. So that's something that's very, very telling as well. So good comment there. Yeah, I think that is good to have streamed trials because you can really see what kind of judge you have. Yeah, Lissy B, he would know. It's just all this I don't recall, maybe all that kind of stuff. It's just very much disturbing to see. Yes, I agree, Katrina Raven. Yeah, it's been really outrageous. Yeah, it's almost like that, isn't it? Is that bizarre? So anyway, okay, let's go ahead and continue on here.
The waterfall video, you did it with Mr. Lally, correct?
The only small portion of it.
Right, but even in that small portion and based on your memory, you don't remember that anybody being stumbling drunk and falling down over stools and things of that nature?
No.
Okay. They appear to be acting appropriately
Yes.
and interacting with others appropriately.
Yes.
People were buying drinks for others, is that right?
I'm sure. I don't recall exactly, but I'm sure that was going on. Yes.
Not that unusual to say, hey, I'll get this round, correct?
Yes.
You left the waterfall at 11:58, is that right?
Yes, approximately.
Who was invited to come over to your house on leaving the waterfall?
Whoever wanted to, really.
You'd been drinking since about what time in the evening or in the afternoon?
9-ish.
That's when you went to the hillside?
Yes.
That's when you had your first drink?
Yes.
And you continued drinking throughout the evening consistently?
Yes.
Did you believe you were okay to drive?
Yes.
What kind of car did you have at the time?
Ford Edge.
Black?
Yes.
Did you drive that car home from the waterfall?
Yes.
Who rode with you?
My wife and my daughter.
What other cars were in the driveway when you got there?
I don't recall. Brian Higgins' Jeep was in the driveway backing up as.
Yeah, that's a good comment here, Sally Williams. And to think that the court knows it's being televised and everyone can watch or review it and they still don't care is very telling. Yeah, it's scary. Yeah, it is. Isn't that bizarre that this kind of stuff goes on and on like this? So, right, Lola Ritz, I'm a paid puppet of Karen Reed. Now, I think you got it totally wrong. I'm just talking about justice matters, and no matter what side it comes out, if I see wrong being done, then I'm going to speak out about it. So even if there's trolls like you, even if there's paid trolls by you, maybe you're part of the Albert crew. So obviously you're not here to have a legal discussion if you think I'm a paid puppet. So I think you're the one that's a paid puppet. So anyway, I'm not worried about you trolls because in the end, truth is going to come out. She's not going to be convicted of murder. And for you to see this kind of testimony and have no problems about it whatsoever, that you think this is legitimate in America for prosecutors to act that way, you know what? I've seen it before. You'd be the first kind of person to call me up if you get falsely accused of something. And then all of a sudden your tables are turned and you're like saying, oh, I had no idea. I didn't believe the system could be this bad. And yeah, okay. Well, guess what? A little too late then, maybe.
we pulled in.
So kind of in your way.
Yes.
In other words, you weren't going to park him in.
I didn't want to block him in.
Right. So you waited until he moved his Jeep out of the way.
Yes.
And then you pulled in.
Yes.
Where in the driveway did you pull in?
I believe I pulled to the left side of the driveway.
You would have been closest to the garage, or was there a car between you and the garage?
I would have been closest to the left side walkway. I don't think there was a car in front of me, but I'm not 100%.
Mr. Albert, did you move that black Ford Edge at any point?
I don't know anything about this comment here, but I'm just posting it.
That night after you got home?
No.
Brian Higgins was the first person to actually physically get to the house. He got there before you, correct?
Yes.
Describe his Jeep.
He had a Jeep Wrangler. I believe it's white. I think it's white.
Any appendage on it?
A plow.
A snow plow on the front?
Yes.
That can hydraulically go up and down?
I didn't see it that closely. I'm assuming it can, but I don't know that for sure.
After Mr. Higgins moved out of your way, out of the driveway, where did he put that Jeep?
I don't know. I don't know where he parked.
So you wouldn't have gotten to the house if you left Waterfall at 11:58. You have to get out to your car, get in your car, start it up, drive home, wait for Brian Higgins to move his Jeep, park your car, then get into the house. That's a fair assessment of the mechanism of you getting home that night, correct?
Yes.
You wouldn't have gotten into the house until, what, 12:15? Maybe 15 minutes for all that?
I would put it more, maybe 10 past 12.
Okay. 12:10 or so?
That would just be a guess.
So it could have been 12:15.
Yeah, and it could have been 12:07.
Who was inside the house when you walked in?
My nephew Colin, my son Brian, and then he had two friends, female friends. I believe it's Sarah and Julie.
What were they doing inside the house?
They were just sitting at the kitchen table.
And your nephew, Colin, How old was he at the time?
I believe 17 or 18.
Describe him.
In what way?
Height, weight.
So 2.5 years ago, so he was probably 5'11", maybe 6 feet, and probably 100 and, I'm guessing 175 pounds.
Big boy.
He's
Not a small kid.
right.
I mean, bigger than me, significantly.
Yes.
So there he's given the height and weight estimated. Those are the kind of things you can not know for sure. But so this is the kind of thing that is not indicating any kind of deception. But
Athletic guy.
why isn't that
Yes.
with everything else?
Played football.
Right?
Yes.
Good at football.
Yes.
You testified that you went to the bathroom after you arrived home, correct?
Yes. After saying hi to everybody, I went to the bathroom.
Was that upstairs or downstairs?
I'm not sure I have a bathroom downstairs and not downstairs, but on that floor and then upstairs. So I'm not sure which one I went to.
When you came
I think
back
it was
home-
upstairs.
I'm sorry, I didn't mean to.
I think it may have been upstairs, but I'm not sure.
When you came back downstairs from the bathroom or came out of the bathroom, wherever it was, you no longer saw Colin.
Yes. Prior to going to the bathroom, Colin had said that he was getting picked up.
But you never saw him leave.
No,
You didn't see him leave the house, and you didn't see him get picked up by anybody.
I did not.
You didn't see a car outside waiting for him, correct?
I didn't. No.
You did give an initial statement on the morning of the 29th to Michael Lang, about 7 a.m., is that right?
Officer Lank was in the house at that time and speaking to all of us, really.
And you've admitted that you have known Michael Lang for many years, is that right?
Yes.
Did you see that as a problem?
In what way?
Conflict of interest?
Objection, Your Honor.
I'll let him have it. Did you see that as a conflict?
Okay, why don't you let the attorney handle the questioning of the witness, Judge? Are you trying to protect him? Did you think that this is maybe going to make him look bad? You trying to give him make him feel comfortable that you're asking it and it's safe to answer it? And you're basically cutting off the defense counsel at the knees by you interjecting it. It's a legitimate question. So why don't you allow it to be overruled and so he can ask it again and force a witness to say it? It's again just another sign that this is not a way a courtroom should be run by a judge.
No.
You were asked who was present at the house that night, the night before, right?
Yes.
You stated the following people were at the house that night, quote, in response to Officer Lank's question, at some point during the time in question. That's how he phrased the question. Who was at the house at some point during the time in question? You understood that, right?
I don't recall his question. No.
You knew that he was asking who was in the house.
That's right. Yes.
So you mentioned Brian Albert Jr.,
Yes.
your son. You mentioned Caitlin Albert, your eldest.
Yes.
You mentioned Julie Nagel.
Yes.
You mentioned Brian Higgins.
Yes.
And then you added the detail that Caitlin Albert had left your house about 12:15 a.m., correct?
No,
You didn't say that?
I did not.
I may have just a moment, Your Honor. Yes.
You know, one of the things a lot of times police officers do, they're trained to frequently look over the jury and just let them know they're comfortable testifying in front of them. I have not seen him, correct me if I'm wrong, but I've not seen him look over the jury one time. He's only looking at Lally for like a lifeline support. He doesn't want to look at the jury because he knows he can't come across as credible. That's my assessment of it.
May I approach, Your Honor?
Yes. Show Mr. Lally.
I'm sorry. So you don't have to sit and read the entire thing. There's right at the top of this there's a word that says next. If you would read that area, that next few sentences, let me know when you're finished. Yeah,
Yes.
thank you. Mr. Albert, did you have an opportunity to review that portion of a report?
I did.
Did that refresh your recollection about a conversation that you had along with your wife with Officer Lank?
Yes.
Isn't it true that Officer Lank asked you and your wife who else was in the house that night aside from the names already mentioned? And the names mentioned were Brian Albert Jr., Caitlin Albert, Julie Nagel, and Brian Higgins, quote, who is a friend of Brian Albert Sr., end quote. Is that right?
That's what the report says, yes.
And then the report goes on to say, they advised me that their daughter Caitlin left the house around 12:15 a.m. when she was picked up by her boyfriend, Mr. Morris, right?
That's what the report says, yes.
Do you think Officer Lank got it wrong?
Perhaps, yes.
Did you say that Caitlin left about 12:15?
No,
Did Nicole say in your presence that Caitlin left about 12:15?
she did not.
At any point, did Officer Lank ask you what time Caitlin left?
I don't recall him asking that. It was a very chaotic morning, and I don't remember him saying that.
So in fact, if he wrote
Okay, so this time sequence of when that person left his house, if that's an issue and he never told the police that also makes it look like the police reporting is just making up stuff. So no matter how he answers, he either accepts that the family member left at 12:15, or it's something that is completely fabricated, made up on the police report, or maybe somebody else said it and they're getting their wires crossed. Either way, it makes it look like completely sloppy police work.
that sentence in the report, which you just read, he's just making that up.
Objection, Your Honor.
Sustained.
I'll ask it a different way. If that's what Officer Lank recalls, he's just wrong, right?
Yes.
Anything else that he's wrong about in there?
I didn't read the whole report.
At no point, isn't it true that at no point during that interview did you admit or mention that
Wait a minute, he wouldn't read the whole report. The murder happened outside his house and he didn't read the whole report. I would have pulled the thread on that one right there.
Colin Albert had been at the house that night?
I don't believe I did, no.
At no point during that interview did your wife, Nicole, in your presence, admit or mention that Colin Albert was in the house that night?
No.
So did both of you conveniently forget that Colin was there?
Objection.
I'll ask it a different way.
Sustained.
Did you forget that Colin had been there?
No,
Is there a reason that you left his name out?
because he wasn't there. He left when we got there. He wasn't there for the duration of the,
So Colin's a nephew, so he obviously doesn't want his nephew being placed there as well. So see what he said.
of the time that we had that night.
Except for the fact that you just testified that you never saw him leave, correct?
Well, he said he was getting picked up and then he was gone. So I assumed he left.
People say a lot of things, but you didn't see him leave and you didn't see him in the
Yeah, chaotic morning. Yeah, he missed it all. He slept in all those sirens, lights, all that kind of stuff. He just completely missed it, which I'm gonna get to that later. But yeah, there's so many things about this witness that are just unbelievable. So I think we're at an hour and 34 minutes. So I think what we'll do is we'll have parts 1 and 2. So we'll go on for another 25 minutes or so, and then we'll have a redo maybe tomorrow night for part 2. Not a redo, but we'll do part 2 and finish the rest of his testimony.
the regular floor of the house, according to you, correct?
Right.
Ground floor of the house.
Right. He was no longer in my house. So he left.
Well, you didn't search the house, did you?
No,
And you never saw him leave.
I didn't physically see him leave. No.
You also gave a statement to Michael Proctor later that morning. It was about noon, maybe it was in the afternoon, noon, 12:30, something like that.
Are you asking?
On the 29th, you later, after you spoke with Officer Lank, you later were interviewed by Trooper Michael Proctor over at Jim McCabe's house. Do you remember that?
Yes.
Colin's name was never mentioned then either.
No, because Colin wasn't at the house for the duration of the night.
So when they said who was in the house, talked about Brian Albert, Caitlin Albert,
Yes.
folks in the house,
Yes.
Nagel.
Yes. There were other people in the house prior to us arriving. I didn't mention them either.
Who was that?
There were some females, friends that were over prior to our arrival, and
But you never even saw them.
no,
So you have no idea who was there and who wasn't there before you got there.
I know that there were people at the house prior to me getting there.
Mr. Albert, the question that has been posed to you by several officers was, who did you see in your home when you got there, correct?
Objection.
I'll allow it.
Well, I'm glad she allowed this. I mean, normally wanting to know or failing to mention who else was in your house that night was not a big deal. But we're talking about a murder case here. It's something that should be investigated. Everyone else in the house that night, just not during a certain window from the time that John supposedly showed up there. But they need to get the full details out. And so this is something that he, as a law enforcement officer, should know. You need to bring out all those kind of details of what was going on that evening.
I don't believe that's how it was asked. No.
Again, he doesn't believe, and is this talking about the interview at Jen McCabe's house, and he was over there at the time, and the whole thing is just really shady.
But Colin's name was never mentioned. It's left out.
I testified multiple times that Colin was there when we arrived.
Oh, you did it after the fact, right?
Yes, when I was at.
You knew that the defense knew that Colin was there.
Objection.
Sustained.
In your initial reports to the police, his name was never mentioned, was it?
I did not mention it, no.
And Nicole did not mention it in your presence, did she?
In my presence, no.
Let's talk about Caitlin Albert, your eldest. You told Officer Lank that your daughter, well, according to Officer Lank, let me rephrase the question based on our colloquy back and forth. According to Officer Lank, you're aware that he wrote, he was told she was gone by 12:15, correct?
That's what he wrote in the report, yes.
If Caitlin was gone by 12:15, she would not have been there when John and Karen arrived to the house, correct? Because they didn't arrive for 15 minutes later.
But she was at the house, so that would be a hypothetical.
Okay, so fine, hypotheticals. Let me ask you a hypothetical. If in fact Caitlin was gone by 12:15, that would mean hypothetically she would not have been there when John and Karen arrived 15 minutes later.
Objection.
Sustained.
Why does that matter, Lally? Why would the judge sustain it? Legitimate question.
When you were interviewed by Officer Lank that morning, other people were in the room, not just you and Officer Lank, correct?
Yes, I wouldn't consider that morning to be an interview with Officer Lank.
More of a conversation.
Yes.
During that conversation,
So when was he interviewed? Who was he interviewed with? Lang wasn't even really interviewing him, and that was sufficient police investigation.
Nicole was there.
Yes.
Unbelievable.
She was in earshot.
Yes.
When she was involved in the conversation, you were within earshot.
Yes.
Brian Jr. would have been within earshot.
Brian Jr. wasn't downstairs most of that morning, so he may not have been.
But he was there for part of the morning.
Yeah, but I'm not sure that he was there at the time. Mike, Officer Lank was asking questions.
The fact of the matter is, notwithstanding what Officer Lank wrote that you said about Caitlin leaving at 12:15, she did not leave at 12:15. Isn't that right?
She did not, no.
As a matter of fact, in truth, except for the people who lived there, Caitlin was the very last person to leave that location that morning, correct?
I believe so, yes.
And she's admitted that she did not leave until nearly 2 a.m., 1:45, correct?
Objection.
Sustained.
You're aware that she did not leave until 1:45 or thereafter. Is that right?
I believe that's around the time, yes.
Were you trying to cover for Caitlin so your daughter would not be wrapped up in this investigation?
No.
So notice that's the big discrepancy from around 2 o'clock to like 12:15, right after the folks start showing up, she's gone. So yeah, it does look like he's trying to distance something as well. His daughter not being around there. And the later that she left, keep in mind, the more she would be in the position to notice a John O'Keefe laying there along the edge of the road.
But as a reminder, when you were spoken to by the first two officers who discussed who was in the house, you never mentioned Colin was even there, correct?
Objection.
We've gone over that. Next question, please. Sustained.
That was asked, so that was an appropriate ruling by the court, one of the rare ones, I would say. But again, as a prosecutor, what does it hurt? Just let them have it. Just let this trial get on.
If Colin was gone, just like Caitlin was gone, that would eliminate them from ever being at the house at the same time as John O'Keefe and Karen Hoop, right?
Objection.
Sustained.
All right, let me go back.
Never mentioned Colin was even there, correct?
Objection.
We've gone over that. Next question, please. Sustained.
If Colin was gone, just like Caitlin was gone, that would eliminate them from ever being at the house at the same time as John O'Keefe and Karen Hoop, right?
Objection.
Sustained.
That's a perfect cross-examination question, showing the overall bigger motive here. Motive is like the heart and soul of how you win cases many times as defense counsel, is very much exposing the flaws of the government's witnesses. And if you don't have the ability to like package it together and put these kind of evidence out there, that this is what's really going on for this witness's motives. He's trying to distance his family members and get them away from the house as soon as possible. That is what I see as very troubling and disturbing. And it's just, it doesn't look like they're trying to give Karen a fair trial at all.
On January 29th, about 11:30 or 12, we talked about the fact that you were interviewed by Michael Proctor at Jen McCabe's house, correct?
Yes.
You knew at the time that the state police were looking to interview Jennifer McCabe about her understanding of what had happened the night before.
Objection.
Sustained.
Wow, that's
You were no.
again. Why is that? If he knows it, what's wrong with him answering that question? Again, goes to motives. This is totally legitimate line of questioning. It's very disturbing to see. And here's BS. You're asking, what do you think is going on in the mind of Jackson with the judge's behavior? It's just got to be like just something that you're so frustrated with. The prosecutor's just basically trying to cut you off the knees. It's not as bad now as I've seen it during other parts of the trial, but it's just one of these deals where you got to constantly, it's like lawfare. It's not about the evidence. It's not about presenting your case, due process for the accused. It's all about lawfare, and they're trying to shut you down from presenting your kind of questioning, exposing the motives of the government's witnesses. They don't want the motives of the government witnesses being exposed because they know it hurts their case.
Notified that the state police were going to interview Jen McCabe.
Objection.
I'll allow it. Were you notified that?
No.
You knew the subject matter.
Why doesn't she let him? It's like she's trying to cover and protect the witness. This is very disturbing. But it happens over and over again in this trial. You just don't see trials like this normally this bad of a judge interjecting themselves.
Of an interview with Jen McCabe was going to happen over, the subject matter of the night before was going to happen over at Jen McCabe's house. That's why you went there, right?
Objection. No.
I'll allow it.
No.
Isn't it true that you knew you had been notified or at least you believed that an interview with Jim McCabe as part of an official police investigation was going to occur at her house.
Yes.
You were not asked by the police to join her, correct?
No.
You had no official reason to be at Jim McCabe's house, correct?
What do you, I don't know what you mean by official reason.
You were not working the investigation yourself.
No.
You were a witness, correct?
Right.
So you had no official reason to be at Jim McCabe's house during an interview with Jim McCabe.
Objection.
Y'all allow it.
Lally, it's disgusting to see you act that way. You need to read the Constitution, the case law, and the Sixth Amendment Confrontation Clause, because this is an absolute disgrace. Okay? Glad the judge shut you off here, but you do not know your job. I'll tell you that by trying to cut this line of questioning off.
No.
So, but before she gave her statement, you made sure that you were right there to monitor that interview and exactly what was said, correct?
Objection.
Sustained.
Were you in her house when Jim McCabe
Back over that.
never mentioned Colin was even there, correct?
Objection.
We've gone over that. Next question, please. Sustained.
If Colin was gone, just like Caitlin was gone, that would eliminate them from ever being at the house at the same time as John O'Keefe and Karen Hood, right?
Objection.
Sustained.
All right, I've already covered that.
On January 29th, about 11:30 or 12, we talked about the fact that you were interviewed by Michael Proctor at Jim McCabe's house, correct?
Yes.
You knew at the time that the state police were looking to interview Jennifer McCabe.
The reason he's there, I think it looks so obvious, is that he's trying to influence the investigation. He's a Boston police officer and he's taking part in a main witness for this murder investigation, and he's there to show the fact that she's supposed to be treated favorably. He's there to show his presence, that she's on the side of law enforcement and you need to go easy on her. Those are the kind of things. It's like intimidation. He's there to intimidate whoever the investigator is to make sure that they do the right thing in his mind. That's what it looks like. Otherwise, he should not want to be a part of that. He should, if he had to just be there, he should just stepped out of the room. He should not be listening to anything that this conversation is about with the investigator and Jen McCabe. And why is she being interviewed at the house, by the way? Why is she at the house being interviewed by law enforcement? It should be at the police department. That's where investigations should happen of a material witness like this. But no, they want to just do it at her house. Why? Because doing the minimum necessary. It's like a little misdemeanor. That's all it is. And yet we got the death of a police officer. Everything about this case, nothing was done by the book. Nothing was done by the book. It's really bizarre.
About her understanding of what had happened the night before.
Objection.
Sustained.
Garbage, absolute garbage.
You were notified that the state police were going to interview Jen McCabe.
Objection.
I'll allow it. Were you notified that?
No.
You knew the subject matter of an interview with Jen McCabe was going to happen over, the subject matter of the night before was going to happen over at Jen McCabe's house. That's why you went there, right?
Objection. No.
I'll allow it.
No.
Isn't it true that you knew you had been notified?
Lally, again, it just really turns my gut to see him acting that way. It's not right. It's totally wrong as a prosecutor.
Or at least you believed that an interview with Jim McCabe as part of an official police investigation was going to occur at her house.
Yes.
You were not asked by the police to join her, correct?
No.
You had no official reason to be at Jen McCabe's house, correct?
What do you, I don't know what you mean by official reason.
You were not working the investigation yourself.
No.
You were a witness, correct?
Right.
So you had no official reason to be at Jen McCabe's house during an interview with Jen McCabe.
Objection.
Y'all allow it.
No.
Hi, Lally.
So, but before she gave her statement, you made sure that you were right there to monitor that interview
That's another good one.
and exactly what was said, correct?
Objection.
Sustained.
Were you in
Why?
her house
That is totally
when Jim
legitimate.
McCabe was interviewed by Michael Proctor?
That's most likely the thing he was doing. Just like he's bobbing and weaving and deceiving now, he was trying to make sure he had control over what was happening. He could pass information on. He could tell it to the other family members and the McCabe's how to handle it and what he thought of how they did and all that kind of stuff. I mean, it's totally like he knew he had to control that situation. You're only trying to control it if you know the truth hurts you. That's what's obvious to me.
Her house, yes,
You had gone to her house, correct?
I did.
You went there before she gave the interview.
Yes,
So you were there in her house during the entirety of her interview, correct?
I believe so, yes.
And importantly, Jen McCabe knew you were in her house during that interview, correct?
I assume she knew, yes.
I mean, you're in her house after all.
Yes.
I want to get back to 34 Fairview if I could. In the early morning hours of January 29th, Brian Higgins directly.
Keep in mind, he does not want to make contact with the jury. That's something I'm picking up on. Law enforcement officers, again, like I say, they have a habit of looking to the jury. They're very comfortable looking for the jury. He is not comfortable doing that at all. Okay. And what I would do if I was the attorney on this case, if he starts looking at the jury on the second trial, then I would call it out. I'd bring up stuff like that as well. You never looked once at the jury at the first trial. Why are you bringing that up? Why are you looking at the jury now? Those are kind of differences in his behavior. I'd call him out on it. Let him know every little thing he's doing differently from the first trial to the second trial. Call him out on it.
They followed you into the house after you walked in, correct?
Could you rephrase that?
Sure. You walked in, even though there were some moving of cars, you were the first one to walk into the house. And Brian Higgins followed you.
Yes.
Nicole and Caitlin then came in shortly after that.
Keep in mind, he never got out of the house to go see what was going on with a dead police officer in his yard. And yet he's over there for Jen McCabe's the next day, right? So suddenly has a newfound interest. Doesn't add up.
I think Nicole and Caitlin probably came in around the same time as me. And then Brian Higgins.
Sorry. Did you make another drink once you walked into the house?
Did I make a drink?
Did you make a drink? Grab a beer?
Yes.
Okay. When I say make a drink, did you get a drink?
Yes.
What drink did you get?
I don't know. Probably just would have been whatever was at the house, a beer or something.
Okay. Did Higgins have another drink?
I don't know.
What did you do? What did you and Brian Higgins do once you were inside the house?
We just kind of hung out, talked.
At any point, did you and Brian Higgins go down to the basement?
He looks very nervous. Look how his eyes are shifting around. Very nervous with that question. Why is he so nervous?
No, I don't remember going to the basement.
You don't remember going to the
Again, he doesn't remember. You totally know every detail that night. This is what happens as a law enforcement officer, especially you have heightened awareness of your surroundings, what's going around you, especially if you find out somebody's dead hours later in your front yard.
the basement, or you didn't go to the basement?
No, I didn't go to the basement.
Did Brian
Okay, now when he's cornered on it, now he said, well, no, now I didn't go down there. So which is it?
Higgins go to the basement?
Not that I know of.
How would you not know if he went in the basement or not? How would you not know that? That just doesn't, none of this is coming across as credible.
And you didn't go upstairs to the second floor, did you?
I think I did go upstairs, yes.
Isn't it true that Brian Higgins has never been upstairs in your house?
Prior to that night?
Ever, including that night specifically.
I don't think that's true, no.
You owned a dog at the time, correct?
Yes,
It's a German Shepherd named Chloe.
yes. Mix.
Describe that dog as being not great with strangers. Isn't that true?
I did describe it that way, yes.
You testified that, quote, it started barking because it realized that people were downstairs, end quote, right?
Yes,
Chloe had a penchant for barking when she heard people, correct?
no, not necessarily.
She did that night.
Yeah, I think she wanted to use the bathroom.
Yeah, okay, how convenient. Wasn't this dog a German Shepherd? German Shepherds are notorious for being guard protective type dogs, and any kind of chance they get, they're going to be barking. I even hear them here every morning. As soon as they're let out, they're barking and barking and barking. So anyway, it's very much an odd comment to make.
Well, that's not what you said in your testimony. You said it started barking because it realized there were people downstairs, right?
Right.
So your German Shepherd, probably a decent dog, guard dog, if she heard commotion and people, she would bark.
Objection.
Sustained. You can ask it differently.
Obviously, if Chloe hears commotion and people, she's apt to bark. That's the only question.
No.
So just that night, out of nowhere, first time ever, Chloe starts barking when people walk into the house.
No, it's not the first time ever, but she didn't bark often.
Okay. But she did bark that night, right?
Yes.
So he says she didn't bark often. I mean, that doesn't make any sense. If he says she did bark often, then why wasn't she barking and waking him up the morning?
The reason that you gave under oath for why she started barking was because there were people downstairs knowing about, right?
Yes.
So in that instance, on January 29th, in the early morning hours, she was barking because she heard people.
Well, I can't say why she was barking.
Well, you did say why she was
Yeah.
barking,
I let her out to use the bathroom, so I think that's probably why.
except your testimony.
He did also refer to the dog as it. I think he just said her now, but you refer to your dog as it. That's another strange comment there.
Was it started barking because it realized there were people downstairs. Those are your words, Mr. Albert, not
Right.
mine.
Okay.
Do you stand by those?
Yes.
Okay. You ultimately did let Chloe out to go to the bathroom, correct?
Yes.
And then you allowed her to stay downstairs and you monitored her with the others who were in the house. Isn't that right?
Yes.
As a matter of fact, you testified in that state grand jury, the same April grand jury, April of 2022. So I let it go out to the bathroom. I let it back in. I kind of monitored it a little because we usually don't have people over the house and the dog's not great with strangers, period. So I was just making sure that the dog was all right with the people that were over, end quote.
Think again about what he said. The dog is not great with strangers, and you got all this commotion, you got ambulance, you got all these police cars out in your front yard, and the dog is not doing anything to alert you, not barking, not making any kind of disturbance in your house. I mean, that's just not even credible. Not credible at all. And so the question is why? Why would he say that was what was going on with the dog? It's just not credible. Nobody on the jury is going to believe that.
Correct?
Yes.
So in fact, you did keep Chloe downstairs at least for a period of time with people that were over, right?
Yes, for a few minutes, I think.
Mr. Albert, after you learned that there were questions being raised about John's injuries and dog bites and scratches, in May of 2022, you got rid of that dog. No?
Objection.
Sustained. You can ask it differently.
At some point,
What? I don't get it. That's a perfectly legitimate question. Lally, again, you're not trying to give the guy a fair chance line of questioning here. You don't understand the Sixth Amendment right to confront the prosecution witnesses. It's just very tough to see this going on. Not fair justice here at all.
your family got rid of Chloe.
Chloe was rehomed in May
And we can use
2023.
whatever words we want to. Rehomed, rehoused, whatever. But you got rid of her. She's no longer part of the Albert family, right?
Objection.
Allow that.
Right.
When did you get rid of her?
So Chloe was rehomed in, I believe, May
Of 2022,
of 2022.
just months after the incident we were discussing.
Well, after it was involved, she was involved in a dog fight with another dog out front.
Right, but that's also after the incident.
Yes.
Sounds like an aggressive dog, right? They had to get rid of it. So
Yes.
Yes, May.
That's a family pet that you had for 6 years or 7 years.
Approximately 6 or 7 years. Not
Your
sure.
explanation,
yeah, that doesn't sound right, does it? Dog you have for 6 or 7 years and you get rid of it? And it was out in the front yard. No, why would the dog be out in the front yard? They have a fenced-in backyard.
Just now for having gotten rid of that dog is because it bit another dog and ultimately sent 2 women to the hospital, correct?
I believe 2 women went to the hospital. Yes.
But you took no action to get rid of Chloe until after you knew that serious questions were being raised about John O'Keefe's,
Objection.
correct?
Sustain.
Wow, that is so legitimate line of question there that Lally, I don't have the words to describe how disgusting it is to see this kind of questioning being blocked. And the judge, this is not a fair trial, folks, not at all.
At some point, you did realize there were questions being raised about John O'Keefe's injuries on his arm, correct?
Objection.
Don't allow that. Did you realize that?
I heard some talk about it. Yes.
Again, trying to help control the witness, cut the defense counsel off from them having control over the witness. A lot of things you do as a defense attorney is you're trying to have control over the witness, right? So you already are not allowed to depose this witness. So you got to go in the courtroom not knowing all the answers he's going to have based on the questions. You sort of got to somewhat do a fishing expedition on. And then on top of that, compounding that, is a judge who's going to interject herself in a line of questioning when she knows she can't grant the prosecution's request to block that line of questioning. So it just, the whole thing is just very, very sad to see. It's not the way justice should be happening in America.
As of January of 2022, John O'Keefe had never been in your house, had he?
John O'Keefe was never in my house before or after that date.
Certainly, John O'Keefe, you would agree with me, he would count, were he in your house, he would count as a stranger to Chloe. Never met her.
Look at that. He can't even answer that simple question. Of course he'd be a stranger if he'd never been there before. So in any event, it's we're over the 2-hour mark now, so I'm going to go ahead and pause it, and we'll resume this. Looking to do it tomorrow night, same time, 8 o'clock Central Time. So thanks for your interest in this case. It's a really bizarre case, and you probably can't see a more bizarre courtroom setting than this case, with not only the government's witnesses that just are lacking so much credibility, but the way the prosecutor is conducting himself, the way the defense counsel is acting. And this is continuing on, even though we have a new prosecutor. Keep in mind, Lally's not doing the second go round here in April. We got this new guy named Brennan, who's defense counsel that's hired as a special prosecutor. So he's being paid to prosecute Karen Reed. And so anyway, it's just still ugly. It's still denial of due process. They're trying to keep out all these constitutionally required defense experts that the defense wants to call. I understand they're up to now 14, I think it is, experts that the defense wants to call, and probably most of those are going to be there's going to be an attempt to be blocked by the prosecution, their motions. So anyway, it's really astounding to see the kind of effort they put into prosecuting this case. And keep in mind, they could not convince a single juror that this is a murder case in the first trial, not a single one. And here they are again trying to prop this up. The judge should have done a directed verdict on the murder charge for sure. And it should have never gone to the trial. That's how flimsy this evidence is. So with that, I'm going to sign off, and thanks for your support for justice. And I'll see you back here later. Have a great night. And I guess here, if you're here in the United States, for most states, we move the clocks forward. So there'll be a change in time tomorrow night from that perspective. But in any event, thanks again. Have a good night.